Good afternoon, everyone, and welcome to today's Regulatory Transparency Project webinar titled Reducing Regulatory Barriers, the Future of Market Competition. We're so glad that you're able to join us today. My name is Libby Dickinson, and I am the Assistant Director with the Federalist Society's Regulatory Transparency Project. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. We're honored to be joined today by an excellent panel of legal and antitrust experts addressing the proposals of President Trump's recent executive order concerning the reduction of anti-competitive regulations and what it will mean for market competition. After the panel discussion, there will be a short period designated for audience questions. We ask that you submit them via Zoom's Q&A feature, not the chat, and that they are pertinent to the topic at hand. In order to get right to the discussion, I'll start by briefly introducing each panelist and then hand things over to our moderator to start the conversation. Our panel today includes Alden Abbott, Senior Research Fellow at the Mercatus Center with George Mason University, Charlie Beller, Counsel to the Assistant Attorney General, Antitrust Division with the Department of Justice, and Kathleen Bradish, the Vice President and Director of Legal Advocacy at the American Antitrust Institute. Our moderator today is Bilal Saeed, a Senior Adjunct Fellow at TechFreedom. You can find out more about today's moderator and panelists at the Federalist Society website, fedsoc.org. That is fedsoc.org. And with that, I will hand things off to Bilal to get us started. Thank you so much for joining us today, Bilal.
Thank you, Libby, and thank you for people for joining, and of course, thank you to our panelists. So, pursuant to Executive Order 14267, the administration has tasked each agency within the executive branch of the federal government and any independent regulatory agency to identify and recommend the modification or rescission of any regulation for which they have rulemaking authority that creates or facilitates the creation of de facto or de jure monopolies, creates unnecessary barriers to entry for new market participants, limits competition between competing entities or has the effect of limiting competition between competing entities, creates or facilitates licensure or accreditation requirements that unduly limit competition, that unnecessarily burdens the agency's procurement processes, or otherwise imposes anti-competitive restraints or distortions on the operation of the free market. Prior to the administration's executive order, the Department of Justice had announced an anti-competitive regulations task force that will advocate for the elimination of anti-competitive state and federal laws and regulations that undermine free market competition and harm consumers, workers, and businesses. And shortly after the executive order, the FTC sought comment from the public on federal regulations that exclude new market entrants, protect dominant incumbents, and predetermine economic winners and losers. So what we have is the FTC with the Department of Justice sort of taking leadership of what you might call a whole of government approach to federal regulatory review. And of course, the FTC and DOJ perhaps advocating at the state level for removal of anti-competitive regulations. So, Charlie, you are the representative from the Department of Justice on this panel. So can you describe the scope of the initiative in response to the president's executive order?
Sure, and I'll start. Thanks first to the Federalist Society for doing the panel and to my fellow panelists. I'll start with a normal caveat that my comments are my own, not those of the administration, the DOJ, or the AAG. And I think, as you noted, Bilal, there's the EO, just for those that are less in the weeds than all of the panelists here. There's the EO, which is one of many, and then there's the Anti-Competitive Regulations Task Force, which is an initiative specifically of the Department of Justice, which I can speak to, and there's a parallel initiative from the FTC. So that's sort of the broader context. So I think it's helpful, given sort of the high level, to even take a further step back to think a little bit about the history and context in which these are occurring, because I think it's important from the division's perspective, from my perspective at the division, for how we're thinking about things. And I like the adage from Oliver Wendell Holmes that a page of history is worth a pound of logic, and I think that's particularly relevant here. In the last Trump administration, there was a similar regulatory review effort by Megan Delrahim, who was the AAG in Trump 45. that goes into some details about the history. I think the most relevant pieces being that really since the mid-century and the starting the Nixon administration, there was a concern about the impact that the New Deal style regulations were having on the US economy. That bled into the Carter administration, regulatory reform efforts. I think most important there being the Airline Deregulation Act. And then we saw in Reagan sort of an institutionalization of regulatory reform with OIRA, and then further deregulatory efforts in the first Bush and Clinton administrations. I like the ADA and the Carter administration ADA as a sort of paradigm for antitrust and deregulatory efforts. And there's a story that, if you'll indulge me, I'd like to tell. It probably will be familiar to a lot of folks in this group, because at the National FedSoc Lawyers Convention last November, Justice Breyer and Justice Gorsuch had a sort of a sit-down conversation. And Justice Breyer was talking about his time in working for Ted Kennedy on airline deregulation. Justice Breyer is an antitrust expert. He actually sat in my seat here at the Antitrust Division as a counsel. And so he knew a thing about antitrust deregulation. And the upshot of that conversation was that antitrust is a critical backstop to any deregulatory impetus. And so I think is really important, is that there can be deregulatory efforts, but under public choice theory, right, if you remove the regulatory barriers and let the free market solve the problems, antitrust becomes increasingly important as a backstop to that private market sorting and competition that ideally comes in and replaces the regulatory apparatus. So I'll stop there. Look forward to hearing thoughts from my fellow panelists, but I thought sort of just having a brief history as well as the broader political backstop would be helpful.
All right, thank you, Charlie. And I'll note, as you noted, of course, Ted Kennedy and Stephen Breyer were instrumental in President Carter's deregulatory effort. Jim Miller and also Tim Uris, who both at different times became chairman of the FTC, were part of the Reagan White House's task force on regulatory reform, right out of the start of President Reagan's presidency. But anyway, let me turn to Kathleen and ask, the FTC and DOJ have been aggressive players, right, over the last 40, 50 years in a deregulatory effort. Charlie described a little bit of it. What do you think, are there areas that the FTC and DOJ should be focusing on during this administration, that sort of aligns with the push for removing regulatory barriers to competition?
Yes, and I will also thank the Federalist Society and my panelists for participating today. So I think, to answer your question, the FTC and the DOJ have an incredibly important role in avoiding and eliminating anti-competitive regulation. They are the ones that have the skills and the experience to assess the competitiveness of markets. And they, I believe, can spot issues that other agencies may not be able to. They also have the experience collecting and working with evidence to assess justifications like privacy, safety, et cetera, that are typically offered by parties when they seek market restrictions. They do this as part of their day-to-day job, and it makes them very well suited for this part of the project. And an example of that is the FTC recently filed an amicus brief in the Google search case, debunking privacy justifications that had been raised by Google. So in that respect, their role as an interagency advisor is really, really vital. I saw this firsthand when I was at DOJ and served on the trade committees, the interagency trade committees. A lot of that doesn't necessarily get seen by the public all the time, but it may be one of the most powerful roles that they have. And I hope that this executive order serves as a means to really open the doors of communication among the agencies. And I think it can be really a good point of continuity between the work done in the Biden administration with the whole of government approach to competition and this administration. So, and second, I'll just put in a brief pitch for the FTC's powers to conduct market studies. This is something I think that can be essential to this project. I think of the pharmacy benefit manager study, for example. And it's part of what makes FTC different than the DOJ and gives it extra tools in its toolbox. So, and finally, on the state regulation side, FTC and DOJ have a really important role in advocating against anti-competitive regulations on the state level, advising state legislatures, and sometimes going into court when self-regulating bodies, I think of teeth whitening and teledentistry come to mind, put in place self-serving and restrictive conditions. In terms of areas where this can matter, I think market concentration can help lead the way to the problem areas. FTC and DOJ can help identify areas where market concentration is very high, areas where it has increased substantially in recent years, and really look for the role that regulation might be playing there. I looked through some of the comments to the DOJ and FTC RFIs on this, and I see a lot of concern about healthcare consolidation, for example, at various different levels. And that raises questions about limitations, for example, about rules that may be creating healthcare deserts in rural and low-income communities, or reimbursement schemes that may be in favoring incumbents over new entrants. Just as another area, agriculture, I see that a lot in the comments. There is tremendous consolidation in meat packing, for example, in seeds is another area, genetically modified seeds. So there it's worth looking at restrictions on independent slaughterhouses, for example, and at the Plant Variety Protection Act to see whether those are getting the balance of safety and protecting innovation and competition right. So I think where you have 2 or 3 or 4 players, like meat packing and genetically modified seeds, I think there's a presumption that something is not working and regulation may be playing a role in that.
Yeah, that's interesting. I mean, the agencies, I think, did identify a few sectors where they were going to focus or might focus their efforts, and of course, healthcare and agriculture, energy, I think real estate markets.
So well, I'm happy to jump in there quickly, and then we can let Alden, be responsive too. But I just wanted to note on that because 2 of those industries are areas where the AAG specifically identified, I believe in the context of the Anti-Competitive Regulations Task Force, agriculture and healthcare. I talked a little bit about airlines before, so transportation is already something that has sort of a long legacy of deregulatory, but I think agriculture and healthcare less so. There are obviously pocketbook issues, and that's an area of concern for enforcers generally. But I think it also fits in with the public choice literature, right? These are industries where you do not have the type of institutional interest to push back on regulation. And so it fits very nicely with the larger sort of theoretical backdrop of why we're doing this work. And that's, I think, to Kathleen's point, particularly acute in healthcare, where the average consumer of healthcare just is not able to push back, like may be the case in transportation or other industries where there's larger industry groups.
So Charlie, I'll just pick up on that before I turn to Alden, and maybe Alden can weigh in as well. I mean, is it do you think a concern, particularly of the Justice Department, but maybe also the FTC, that agencies like agriculture and HHS and either Department of Transportation or the Surface Transportation Board? I mean, you mentioned public choice. Is there a concern these agencies have sort of been captured, and that the FTC and DOJ have to be maybe a little more public in their pushback on the regulatory framework that those folks have both sort of adopted but maybe failed to manage in a way that does not protect incumbents?
I can't speak to the first point, but I think, again, I would just sort of think about it from the perspective of the first principles of public choice theory, right? These are areas in which consumers and there are not sort of organized interest groups. And so I'm not sure I can speak to the specific question, but I think the way I'm looking at it sort of answers the same question, which is there are going to be industries in which consumers do not have the ability to organize. And those could be areas where antitrust deregulatory efforts are particularly important. I think some of the ones that Kathleen pointed to me, are prime examples of that. And those are the ones that the Assistant Attorney General has also identified.
Super. So Alden, let me get you in here. Any reactions so far? It's what we've heard so far from either Kathleen or Charlie. I mean, you and a colleague put a very good comment to the FTC, and I want to turn to that later. But I just wonder if you've got reaction to the areas that Kathleen mentioned and that Charlie mentioned. Maybe you can also pick up on the public choice stuff.
Yeah. No, I think this is all very helpful, and thank you to the Federalist Society for inviting me. I'll just mention in passing, I held a job Charlie currently holds in 1984 to 85 at DOJ, except in those days it was called Special Assistant to the Assistant Attorney General instead of Counsel. Counsel sounds a lot fancier, I think. But anyway, yeah, public choice, I think there's a specific example of that. Some of the restrictions are in agriculture. Something called agricultural marketing orders overseen by the Agriculture Department, which basically limit or apply to certain crops, especially certain fruits, and they limit the production and they allow informal quotas to be established and set prices. Very anti-competitive. It seems cartel-like, and these agreements are overseen. There are industries involved in drafting them, but overseen and approved by the Agriculture Department. And lore has it that in 1981, the head of OIRA, who was trying to oversee deregulation, Christopher Demuse, thought these are terrible. We just get rid of these and we're going to lower agricultural fruit prices. And he made a pitch to the cabinet, and he was torn apart apparently by the Secretary of Agriculture, who said this is nonsense. These orders are part of our agricultural system. How dare anyone question them? And apparently he was sort of shamed into silence, and that was that for the agricultural marketing orders. So it is a reality. If you want an example of, and I'm sure the Secretary of Agriculture was just reading the talking points written by senior career people there who were behind the entire agriculture marketing system. So it is a problem. Now, areas, agriculture is an area. There's also something called a Capper-Volstead Act. That's an antitrust exemption for agricultural commodities. But a lot of things create barriers to entry. That's certainly the maritime and cartel-like agreements. For example, maritime trade, there's something called you can't, if you're a foreign tagged vessel, foreign producer, you can't have your vessels participate in coastal trade in the U.S. from one coastal port to another. That's prohibited by something called the Jones Act. Problem is the Jones Act, which was supposed to promote the shipping industry, really hasn't. In fact, it's lagged. It's become less efficient, U.S. ships, and it's prevented all sorts of anomalies. That containers would go from one port full, and if they were empty, they couldn't, and other ships that were not tagged couldn't pick stuff up. There's a whole host of studies about how the Jones Act has raised prices. Agricultural, really statutorily supported, but in agriculture, sugar quotas. The quota for U.S. sugar production limits the number of imports, limits the percentage of total sugar sold in the U.S. that's imported, and that's benefited a small number of very powerful producers. There's one famous family, I won't mention it, don't want to get into names, but in Florida, originally from Cuba, which in past presidential administrations fought hard to retain those sugar quotas. And again, I think the Agriculture Department and certain trade interests were supporting that. So this is very difficult because you are going up against entrenched interests. You have issues in energy regulation. There have been attempts, let's say, to deregulate electricity generation, but there are these big regional transmission networks, and overseen by the Federal Energy Regulatory Commission. There was often you get these very complex rules. There's a rule called Rule 1000 enacted in 2012 that basically required all sorts of cost sharing in different parts of the country to support improvements in the transmission system. The idea was supposedly to enhance competition, and there are a number of studies that suggest that there have been billions of dollars, if not hundreds of billions of dollars in lost welfare, because this has created confusion. It's been highly bureaucratic. There have been efforts to reform that. There was a new order last year, but this is sort of endemic in all the old and regulated industries. So I think the Carter and Ford administrations, Carter did a good job in trying to go after some traditionally highly regulated industries, interstate trucking, aviation, but it's still the case that sectors of, transportation, as I say, shipping, agriculture, energy transmission still are highly regulated. And again, usually it was a sort of a safety and soundness or natural monopoly in the case of energy, or ensure the orderly survival of the industry in agriculture. This was during the Great Depression, supposedly protecting small farmers. So lots of these justifications that were originally supported these regulations make no sense in today's world. But anybody trying to repeal these things is going to have a fight on his or her hands.
So I want to come back to some of the points you just made. I want to give Kathleen and Charlie a chance maybe to react to it, but let me also throw out another question that I think I had not anticipated raising, but all the talk about agriculture and transportation reminds me that the state action doctrine, right, is an outgrowth of an attempt to regulate, I guess a successful attempt to regulate at the state level or protect competition at the state level among raisin growers. And sort of the North Pennington comes out of sort of efforts with respect to transportation. So as the agencies think about deregulation efforts, should they also be thinking about a stronger push on state action and NOR protections for, basically either seeking regulatory protection or having granted regulatory protection?
May I just add one quick footnote, Bilal? Interesting thing is that in Europe, state-owned enterprises are subject to the antitrust laws, even state-owned monopolies. And that is not really the case in the United States. Tennessee Valley Authority involved in energy, and the problem is you get a monopoly that tries to exclude entry in areas where competition might be possible. Postal Service is famous for that. It's subsidized first-class mail by trying to make it more difficult also for competition to arise in outside its natural monopoly, sort of in packaging. And there's been finally entry by UPS and Federal and FedEx. But in Germany, for example, the German postal monopoly tried to engage in pricing tactics to exclude FedEx and UPS, and they were fined by the European Commission. Now, that can't happen in the US, indeed, because there's a special federal statute that exempts the U.S. Postal Service, which is a corporation coming out of the reference to the postal monopoly in the Constitution, there's a specific statute exempting the Postal Service from antitrust law. So we're talking about regulations, but it could be that if the Postal Service Corporation were subject to antitrust law, you might have more competition in that particular area. So I think there's a lot of justifiable criticism of the Europeans, but perhaps this is one area where we could take a page from Europe.
So I'd also say the state aid issue for Europe seems to get the state aid issue correct. But Kathleen, any reaction to what we've heard so far from Alden and Charlie on sort of the scope?
Yeah. So I will agree with Alden that the FTC and DOJ have a really important role in any effort like this in pushing back on antitrust immunities and exemptions. And I think now well known that AAG Gail Slater, who's in charge of the antitrust division, has talked about antitrust being a scalpel. And I agree, when you're slimming down, if you're working to slim down the need for regulation for market failures, vigorous antitrust enforcement is going to help you do that. It is a scalpel that will encourage that effort. So I think there was also an element of, on scope, how do you determine what to prioritize? And I think, just picking up on what folks have been talking about so far, you can ask the question, where are consumers not getting the services they need? Where are they paying well above margin prices? And where are there bottlenecks, for example, in the supply chain? And I think that can point you to where you can put priorities. And a lot of those are things we've already talked about. Rural customers are not getting services they need in a lot of areas, like healthcare. And agriculture and healthcare are also places where pricing is a problem, and shipping is an area where there's a bottleneck in the supply chain. I just also say that sometimes the barrier to entry is not always just a straightforward prohibition, although clearly those exist. You have certificate of needs for hospitals, for example, or licensure issues that limit who can provide certain services. But it can also manifest in the ways incumbents can be advantaged at the cost of newcomers. So I mentioned briefly before, reimbursements for Medicare or Medicaid. Are they neutral, or are they favoring incumbents? Another example, and I think that's only come to the fore recently, is data. Can data protections that are part of regulations become a way of, I put protections in quotes there, become a way of entrenching incumbents? I think this is a question, for example, with seed companies, genetically modified seed companies, and digital farming. So I think those are all things that need to be taken into consideration when thinking about the scope of this.
Charlie, any reaction to sort of follow up to what
Yeah.
you'd say?
So I think I'll start with that the executive order, at least, is focused on federal regulations. So that is an important sort of independent component of the problem. And I think there's a lot of work. I mean, there's a lot of problems, and I think nobody would dispute that there's enough work to be done in federal regulations alone. On the state question, I would just raise that I think there's a lot of broader legal issues more generally. It's not to say state level regulations aren't an issue. I think if you look at North Carolina Dental, any of the recent state action enforcement, obviously there can be state regulations that are an issue. Alden raised sort of the state aid framework in Europe. This is just a personal observation, but I think the European history suggests that their competition laws had sort of perceived a necessity towards federal antitrust enforcement at the state level to prevent things like tax competition that here in the United States, I think there are not many people critical of tax competition as potentially being a beneficial concept. So I would just say, I don't think Europe is a perfect model for competition enforcement of local regulatory regulations, because there's a different historical context. And since this is a Federalist Society discussion, I would of course have to note, right, we have, I think, very robust principles of federalism in the United States that these sort of federal enforcement of the antitrust laws have to consider. All of which is to say, just I think makes the state level issue all the more difficult, even if there are significant problems and even more protectionist interest many times at the state level that demand a solution.
Excellent. All right. Well, look, we could talk for hours, maybe even days, on all the regulations that limit competition. And, DOJ and the FTC have limited resources. And, I mean, it looks to me like the FTC is sort of quarterbacking a lot of this effort. So, Alden, I want to get to your comment with Shanker suggests a framework for identifying the, prioritizing regulatory overreach, right, to go after, to seek to repeal or rescind or modify. So I think it'd be helpful for the group, for the listeners, for you to describe your comment.
Right. Well, thank you. Thank you, Bilal. Yes, Shankar Singham, who is a lawyer, economist, I've done work with. He's done consulting work in Europe, UK. Here, we jointly submitted a comment, basically suggesting that we anticipated agencies may say, okay, we're told by the order to list our anti-competitive regulations. How do we identify them? And there's a hint, more than one hint given in the executive order, which is helpful. But there's Organization of Economic Cooperation and Development, which is sort of the rich countries think tank, which located in Paris, 30 plus members. U.S. is a member. Submits economic recommendations and reports, and it did one on competition. In effect, competition advocacy, called Competition Assessment Toolkit. And by the way, in 2019, the U.S. delegation to the OECD under President Trump voted in favor of accepting this toolkit for use by OECD members. And the 4 points they say, look, you should look at in finding anti-competitive regulations. One, regulations that limit the number or range of suppliers. 2, limit the ability of suppliers to compete. 3, reduce the incentives of suppliers to compete. And 4, limit the choices and information available to consumers. And it's got then a lot more granular detail. And it's got second and third volume that gives technical guidance. So people say, okay, those are good principles, but how do I know how to apply them to major regulations in my agency? You look at the volume, and it's very, very detailed, very good, and it can be used for issue spotting, not necessarily to say how bad things are, but to quickly. So I think that would be very helpful. In fact, for use by agencies, particularly since the United States has endorsed it officially, and in fact, OECD members, including Canada, South Korea, Mexico, Greece, Iceland, Romania, various Asian countries, Brazil, for better or worse, have tried to have applied the toolkit. So I think that's something to think about. If you get the complaint, well, give us more detailed guidance. You don't have to get an economist at the DOJ or FTC to write up the guidance. It's already been written up. And by the way, the economist in charge of that is an American PhD economist who served 6 years in the Antitrust Division from, I think, 1999 to 2005. And so that is very helpful. And I also talk more generally, but this is probably a less direct applicability, about an econometric model that Singham and others have developed to try and see how particular regulatory structures distort property rights protection, domestic competition, and international competition. And I think those would be useful more broadly, really in sort of a planning exercise, but by the government. But there is one guy I would highlight. There is a Dr. Casey Mulligan, who is expected to be confirmed as Chief Counsel for Advocacy in the Small Business Administration. He's a professor at the University of Chicago, economist who is specialized in assessing the costs of regulatory systems. He testified several times before Congress in 2001 to 2021, 22, 23 about the costs of the last administration's regulatory programs. And he has says the real problem is that people are going to say, well, let's look at the costs of delays, filling out paperwork. He said, no, the main costs really are distortions in the market. And there are ways of estimating that. It's wrong to think that you can't. He gave the example in an interview I had with him of, I think, a couple of federal regulations whose real negative impact was perhaps 1,000 times larger than the paperwork costs, which had been estimated by OMB at one point in the Biden administration. So I think there are tools. It's a tough thing to do, but since it's some sense all of government, I'm putting in a shameless plug here. I hope Dr. Mulligan, who's worked tirelessly on this area, his brain might be tapped by folks at DOJ and FTC.
Well, of course, I think Casey was in the White House during the first Trump administration.
He was.
So hopefully his views get picked up by the agencies. Kathleen, you touched on this. Maybe I'll ask you to expand on it. What other opportunities do you see for both the agencies and private parties or associations, whatever you want to call it, to play in this area, right? I mean, I'll just make a personal note. When I was head of the Office of Policy Planning at the FTC, that office does a lot of advocacy. Lots of times we're alerted to things by third parties, by affected parties, by firms who may be in a sense harmed or excluded from markets by regulation, by legislation or new rules or interpretations of rules. So how else do people play, and what other opportunities are there?
Yeah. So I think it is really important that the FTC and DOJ continue their advocacy at the state level to avoid anti-competitive state legislation and state regulation. And I think it's really important that they continue to push back on exemptions and immunities in the courts. There's a long history of DOJ and FTC doing that. We mentioned North Carolina Dental earlier. So I think that's another significant component of what the DOJ and FTC can do here. But I also think we can't underestimate the power of private antitrust enforcement. Now, not everybody has the resources. Sometimes you're talking about a smaller group or a group that doesn't necessarily have the resources to bring a big antitrust case. But class action and other kinds of private antitrust enforcement have the potential to really be a good supplement here. We're way past the days, if those days ever existed, when the private actions were follow-on suits to DOJ cartel investigations. And we're, I think, in a new stage of private antitrust enforcement now. And I think a lot of advocates of smaller government and deregulation, et cetera, are starting to see a lot of folks are writing about private actions as a tool that allows maybe more of this public choice aspect. And private plaintiffs can point to places where there are competition issues, the companies being disadvantaged by bottlenecks upstream, the consumers hurt by high prices. The market in some ways selects the plaintiffs. I would just point to, in our case, we did a recent amicus in a 340B case where, and this is a program that allows for low-cost drugs to certain communities. And the case pointed to a competition problem there, a potential conspiracy among the pharmaceutical companies to restrict 340B drug availability. But on the flip side of that, there's also a question of who can participate, and maybe the regulations are too restrictive on who can participate in this 340B program. So that's just an example of where, things that come up in private litigation can point you to where the competition problems are, and they have a really important role in enforcing and doing a market-based job.
Before we move on, I want to note too, although this was not an antitrust violation, I do want to note that during the Biden administration, the FTC did a short study of the infant formula industry. And I think that study, while I identified government regulations that seem to limit the number of firms that could participate in the government, WIC program for formula. And when one of those plants went down, that had a significant effect on the supply of product. So, I think it's interesting. I found that I'll call it the so-called progressive movement on antitrust. There was at least a portion of that movement that seemed comfortable with allowing employees outside the context of unions or professionals outside the context of unions to get together through trade association codes or professional licensing bodies to limit competition. But at least some of the folks on the left in the previous administration, were open to removing or at least to identifying regulatory barriers to competition, including government rules. But Alden, before we turn to questions from the audience or even the end of the program, I'd ask you to kick off a discussion of how do the agencies, how does the government do some of this deregulatory effort quickly, right? I mean, I think of deregulation as sort of requiring, notice and comment processes under the APA, but at least there's a strand of thought that says Loper-Bright, the decision in Loper-Bright removing or overturning Chevron can allow for speeded up deregulatory efforts. So Alden, maybe I'll let you kick a discussion off there and then ask Charlie and Kathleen for comments.
And can I, before we get into that process point, can I just respond to 2 points from Alden and Kathleen on the last topic?
Sure.
So I wanted to address, because it's timely, the comment on the OECD report without taking any view on that report, because the OECD meetings are happening next week. And I think this deregulatory advocacy is an important part of the antitrust mission, right? Antitrust and trade policy are not so separate in many other places in the world, and I think nor regulation. And so I think educating the broader community on the impacts of anti-competitive regulations is an important part of the division's mandate. And I know it's something that my colleagues are focused on in those meetings. So I just wanted to sort of second the importance of those initiatives that Alden raised. And then on exemptions and immunities, which Kathleen talked on, agreed that the sort of limited construction is important. And we, since I joined the division, have filed a statement of interest in the BlackRock ESG case, which it's not a pure regulatory exemption, but it's a passive investor exemption under Section 7 of the Clayton Act. And so I think that is a case where sort of continued advocacy of limited exemptions is an important part of the advocacy efforts. That's also an interesting factual context, right? Because it's an example where I think the attack on coal sort of had 2 prongs, right? There were federal regulatory initiatives like the Clean Power Plan that were struck down in the Supreme Court. And then there were private market conduct that was alleged in the complaint from Texas, where at least as alleged, right, there's activity at the private level that is reducing output amongst coal companies. So I think that's a good way to sort of view antitrust and deregulation, or at least regulatory review, as sort of complementary tools. Just wanted to add that.
All right, super. So Alden, can you just touch on, basically what I think is the effect of Loper-Bright, or?
Okay, well, there is an exception to required notice and comment for withdrawing a rule, according to the APA, and says the agency can forego notice and comment when it finds good cause that notice and comment are impracticable, unnecessary, or contrary to the public interest. Now, contrary to the public interest may be helpful. It applies when the prior notice would undermine a rule's effectiveness or the underlying statutory scheme. As some of the audience may know, Loper-Bright basically said that the courts are the ultimate federal court's interpreter of the meaning of rules, and that there will not be deference to a reading of when there's a so-called statutory ambiguity, an interpretation by the agency will not be deferred to. The courts will say, is this regulation in effect, or rule, the best reading in effect of the statute? So in many cases, it may be possible to say that, look, in some areas, let's say not necessarily just EPA, but there have been some very broad interpretations of the statute, like the meaning of waters of the United States in environmental regulation or land use regulation. And in many cases, it may be possible to say, consistent with the public interest, we find that these readings of the statute do violence. They're not consistent with the statutory scheme at all. And therefore, we feel that, our duty to take care that the laws be faithfully executed, President's duty, that we eliminate this rule because it really does not, it wasn't justified in the first place as a matter of statutory construction. Now, the problem is you're not always going to be able to do that. Some constructions you just may be consistent with the statute because the statute wanted to limit entry, and the regulation sort of gets closer to the. So the question is contrary to the public interest, can you make a different reading, say this inconsistent with the rule's effectiveness? Is it impracticable to really, if you believe that competition is a general policy? So they may, so Loper-Bright decision may be helpful in allowing some rules to be quickly pulled without notice and comment, but not always. And then you can challenge that. There'll be challenges in federal district court on saying that, well, pulling the rule was arbitrary and capricious. And the United States, with the crack lawyers from Justice Department and so on, I think will be on the spot to explain why a particular withdrawal was not arbitrary and capricious. We'll state the reasons, a good call. There needs to be a statement of the reasons justifying bypass of notice and comment. And but as we've seen in recent months, sometimes district courts have shown a predilection for trying to stop activity by the administration that it believes it's statutorily justified to undertake. So we'll just have to see.
Kathleen, Charlie, any reaction to, sort of the process by which this deregulatory effort might take place? And then I have a very good question from the listeners.
I will leave that to the much more adept experts in the federal programs and other divisions of the Justice Department. I'm happy to circle back to something you said earlier on the formula, not comment on that case, but on a larger principle, though. But I'll let Kathleen comment.
Well, I also don't want to wade into administrative law areas that I don't have expertise in. But just as a little bit of an aside there, since we brought up Loper-Bright, I think looking through the comments, I will note that there's a lot of discussion in the comments about the non-compete rule and the importance of of not of being very careful about non-competes and in many cases not restricting them altogether. So I guess there are two sides to that issue, since I think folks may be concerned that the non-compete role and low burp rate might collide at some point.
I'm going to comment on that, but I'm going to ask Charlie to comment as he asked to do.
I don't want to comment on that specifically, but I can comment, Bilal, on without sort of taking any position on the merits of the formula investigations, that the factual circumstance you described there, I think, is one that, could occur in many other industries, right? Where there's a regulatory regime in place. And I think the hard thing from an antitrust enforcer's perspective is to understand, when the exercise of market power is coming from a government grant of monopoly or some market power derivative of that government regulation, where is there an antitrust violation and where is there just an abuse of an anti-competitive rule? And I think that's where antitrust and deregulatory reform can be very good complements, right? Because rather than attempting to use antitrust to sort of get at quasi-exclusionary conduct, you can use deregulation to use the metaphor that Kathleen alluded to, that AG Slater has used, right? Scalpel and just cut out the anti-competitive regulation. And then I think ideally, right, you would not have to sort of stretch antitrust to broader conduct. But I think it's a hard question, but it's one where the deregulatory initiatives can work in tandem with antitrust to combat anti-competitive conduct.
So, okay, so I want to get to one of the questions, and then I have a question too, but I'll also throw something out, Charlie, in response, or maybe as a related to what you mentioned. When the FTC and DOJ drafted the 2020 vertical merger guidelines, there was a comment, I believe by one of the FTC commissioners, that the 2020 vertical merger guidelines failed to include a discussion of regulatory evasion as a form of harm that may come up in vertical mergers. I think it was also excluded or not really referenced or incorporated into the 2023 merger guidelines. But I'll note that the one reason it was not included in the 2020 vertical merger guidelines, that is regulatory evasion is a theory of harm, because there was a view by some of the drafters and participants that that theory of harm was not really an antitrust theory of harm, but a theory of a concern that this was an issue for regulatory agencies to address, if their rules could be gamed in a sense. Yeah. But I just throw that out there because I think it is important to think about, again, as the agency goes forward, right? We have a whole theory of harm and associated with vertical mergers that appears to focus not on conduct arising from the merger, but on the regulatory framework that allows the evasion to occur. So Mike Murray asks a very good question, something we hadn't talked about in our prep. What about the development of standard setting? Standards can be both pro-competitive and an anti-competitive barrier, right? Let me put it this way: should the agencies be thinking about the standard setting process? There were, in the Reagan administration and of course prior, but in the Reagan administration, there was some interesting standard setting cases. There was standard setting issues in some of the like in the Rambus case that the FTC brought now over 20 years ago. We haven't seen a lot of standard setting stuff coming out of the agencies in the past 2 decades. Should we see more?
Well, let me just note, Assistant Attorney General Delrahim, in the first Trump administration was concerned. One of concern, he said, was that the standards process where you had patents, standard essential patents being developed, that there might be a anti-competitive rules to restrict returns, to limit returns to the holders of patents included in standard might be a source of antitrust concern. On the opposite side of the spectrum, I think at the end of the Obama administration, there had been stated concerns about that standards should be developed in ways that prevented, in effect, anti-competitive holdup by patent holders whose after the fact, his patents after the fact were said to read on the standard. So certainly there's been some thought was given to standard setting from two different perspectives in recent administrations. But more broadly, as Bilal said, certainly the Supreme Court has told us that exclusion, anti-competitive exclusion through procedural hijinks could violate the antitrust laws. That was decades ago. So yeah, I think standard setting is always worth looking at.
I would agree with that. And I think standard setting and the problems with self-regulating bodies that kind of act as regulators at the state level are similar, where you have the potential for entities that can stand to benefit from restricting the market or including their patents, et cetera. There's always a role for outside correction to make sure that those conflicts don't, that those interests don't result in anti-competitive effects.
So we have just a couple minutes left. I'm going to throw a question out that, and maybe even a plug that, as some of you know, I have a podcast, Rethinking Antitrust, and the next episode is going to be a discussion with Katie Ambrosi, formerly of the FTC's Office of Policy Planning and other parts of the FTC. We talk a lot about healthcare restrictions, regulations in the healthcare space that have the effect of limiting competition. Of course, they may have positive reasons, safety and health, but I think the ones we talk about are mostly focused on protecting incumbents from competition. And one of the things we talk about, which I want to raise with the three of you, is should the merger review process be used to remove restrictions on entry, right? I mean, there's a lot of talk about moving to sort of back to divestitures as sort of the preferred to litigation to address deals. One thing that I think FERC did in the 90s after the 1992 Energy Act was use the merger approval process to deregulate or require divestiture across sort of the three lines of activity to bring competition into the electricity space. Should the agencies look to remove restrictions on entry as part of divestitures? And I'll give the example that I think relates to something, Kathleen, that you said, which is, hospitals, employees of hospitals, including physicians, and also employees of physician group practices, probably operate under non-compete agreements, physicians especially. Should the agencies be thinking about, as a condition to approval of hospital deals and, physician group practices deals and maybe some others, removing restrictions on the employees, non-compete restrictions on the employees? This would get around perhaps the limitations of a non-compete rule to, in areas where you see potentially real shortages of entry or real shortages of supply. So should they use the merger review process to remove impediments to entry by market participants or potential market?
Well, I do have a concern that could be I could see a use for it, but I also think that it could be a reason to approve something that shouldn't be approved. So I don't think we should be compromising the merger review process or letting things through because there's a condition on it that would ostensibly.
So let me say, it can be a complement, not an alternative.
Yeah.
But
And I think,
your point's a good one. Your point's a good one, but it can also be thought of as a complement.
yeah, I agree with that. And I think we just have to be sure that it's staying in the realm of merger economic analysis, because I think there can be a temptation to go outside that.
Yeah, there has been a critique, and I see your point, Bilal, but there has been a critique about trying to shoehorn non-merger related problems into a merger settlement that there is that legitimate role for the agency to be playing. If the agency is a concern about some other aspect that's extraneous to the merger, you shouldn't. So that there's that contrary argument, and I haven't thought at depth about that, but it seems to me there's some conflicting thoughts.
I'll answer in a little bit of a roundabout way, which may not be fully satisfying, but I think is responsive. If you look at Deputy Assistant Attorney General Bill Renner's comments and speech on merger remedies that he gave at GW a week or two ago, I think it focuses a lot on the Tunney Act context in which merger settlements take place. And one of the points he made in that speech is that disciplines enforcement. So to follow on Kathleen's last point, right, to make, to the extent that an enforcement action is predicated on Section 7 and not broader issues, right, I think that Tunney Act structure gives some discipline to the process on, a hard question, admittedly, Bilal.
Okay, so I think we are just after 1. So unless there are any other comments anyone would like to make or questions from the attendees, I think we're about to close out. Is that right, Libby?
Yes, I think that just about wraps it up. But thank you so much for moderating, Bilal, and thank you again to everyone on our panel for joining us and for sharing your insights today. Thank you also to our audience for tuning in and for your excellent questions. And for more content like this from the Regulatory Transparency Project here at the Federalist Society, discussing the regulatory state and the American way of life, please visit us at regproject.org. That is REG, regproject.org. Thank you so much.